you, as an officer of the court, which of those please,
No, I will not give you time when you seem not to understand me.
After the extensive judicial jabs we saw being thrown throughout the morning at the Madlanga Commission, you might think that, okay, we've heard enough, that's it. Actually, things are getting more interesting because it has been reported that Vusumuzi Matlala is about to conclude another plea deal with the IDAC. Yes, and I think that is very true.
After that plea agreement fell away, the Pretoria Commercial Crime Court on Monday, our sources were saying to us, watch, he wants to come to the commission, he wants to share all the information, and he's probably going to go back even by the 11th of September when he's back in the regional court, or he might go back to the Commercial Crime Court and try to ratify and try to put his signature to this particular plea deal.
On the other hand, we're also finding out that the reason why Suliman Karim is actually running away from submitting his bank documentations at the Madlanga Commission is because he might be in serious trouble with the SARS.
Do you think that's why they're actually requesting these financial statements to see if whether, firstly, he is not evading tax, secondly, that there is an auditor looking into his financial books as well, and compliance in terms of how they've been awarded tenders and if the work was executed in some of these areas in the Northwest?
Pule, there's no doubt that Suliman Karim is well connected, especially in the Northwest. We know he's a treasurer for a local regional ANC branch in the Northwest, in the Mafeking area. We know that he's received a lot of tenders, especially road tenders, from the provincial government.
In this video, I wanted us to talk about everything that has happened, those jargons, legal language that we saw happening at the Madlanga Commission. It was extremely interesting, and I wanted us to actually talk about it. If you're interested, let's get to it.
Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
This morning, we saw what was happening at the Madlanga Commission. We were expecting the testimony of Vusumuzi Matlala, well-anticipated testimony that we all wanted to hear about. And it's very much justified because ever since the Madlanga Commission started, ever since the 6th of July, Vusumuzi Matlala has been heavily implicated. And we wanted answers, especially in a platform like Madlanga Commission. Not that I'm discrediting the platform of the ad hoc committee, but I think the Madlanga Commission could go and question him, extensive questions regarding his involvement in the cartels, the 360 million tender, and everything else that we've heard about Matlala. So his appearance is one of the very most important appearances that would have happened at the Madlanga Commission. And it started very dramatic. People were even saying, oh my God, this lady's fighting with the Madlanga Commission and all of that. And I've also heard a lot of people also applauding her way of arguing, right? And how she really construed her arguments and ensured that she's able to convince the Madlanga Commission for purposes of a postponement, because the matter has currently been postponed to the 1st of September. But she came with like a lot of challenge in the Madlanga Commission, meaning she was challenging the commissioners with regards to putting her arguments as to why she thinks a postponement is the probable thing to be done in this particular situation. I know some of you might have liked her, some of you might not have liked her, but here is my take regarding her approach to this. So it seems like her argument relied on two big things. And the first one is the fact that there's a trial that is going to commence on Monday regarding the attempted unaliving of Tebogo Tobejane, and she also relied on the IDAC null and void plea deal. That's how the court defined it, or that's how it is after Matlala said that he does not want to comply with the plea deal anymore. So I want to start with the trial. So she used the trial saying that, citing the section 35 specifically of the Constitution. So we know that section 35 of the Constitution specifically speaks about fair trial, speaks about the right to not self-incriminate, and it also speaks about the issue of the right to silence. So that is what section 35 of the Constitution is about. So she cited that, using that as a basis for her to not continue with the testimony, because she says that at least the trial needs to start. Even though it seems like her big argument was that The trial needs to finish. Actually, Matlala needs to go through the trial stage, finish, for him to come and appear before the Madlanga Commission, so that he does not discuss things that are sub judice or things that might incriminate him, that might be used.
It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty bound to come and do at the Commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc.
And I'm not going to lie, this is an argument that Matlala has been using, not just with this current legal representative, which is Annelien van den Heeven. Annelien van den Heeven came with this argument, and for me, it became like a deja vu moment. If you guys remember at the ad hoc committee, Matlala used the exact same strategy that he's using right now at the Madlanga Commission. It's just that at that time, probably the members of parliament did not take it and did not just agree to it, because he attempted also at the ad hoc committee to not appear, pleading the same situation of the fact that his documentation is not properly structured and that things are not done, so they want a postponement, even though the members of parliament left parliament and went to him. It's the same situation here.
I would love to help about that, but like I said, I think we're going now into deep inside the contract of SAPS, which I said earlier that I do not want to speak about that now as this is an ongoing investigation. So can you please just respect that? I do not want to incriminate myself or compromise the investigation.
So what is happening here is that Matlala had an unsigned affidavit that it's an unsigned documentation or affidavit that he submitted. Secondly, not just the issue of the unsigned document, but the fact that they're using things like his trial or things that are before the court for them to actually justify this postponement that they literally got. So she's using this right, and the fact that there's also that plea deal that he was supposed to conclude with the IDAC, but it fell away because the judge did not agree. He vouched for 12 years, while IDAC wanted to give him 8 years. Then it fell away.
I've been informed by counsel on your behalf in respect of the cell, accused 2 and 3, that it is your choice to withdraw from the plea and sentence agreement as you decline to accept the court's recommended sentence. Do you confirm in respect of yourself that is the position?
Yes.
Accused 2? Do you confirm?
Yes.
And accused 3?
Yes.
But from the conversation that Advocate Van Heeven is actually having is the fact that Matlala, the Matlala concluded this plea deal with another legal representatives. She was not there, and that she wants to peruse through that plea deal to see everything before she can actually, move on from that particular deal. The way she's putting it is as if she has until Monday for her to go through everything, decide and look at what the particulars, the things that were said in that particular plea deal. Because she believes that there's some information that is contained in that plea deal that might actually incriminate Matlala in the long run. And that might be very problematic. That is why she thinks that it is best for her to actually see what is contained in the particulars of that plea deal, because she got briefed after Matlala concluded and negotiated with IDAC.
We were not involved in those negotiations. We know what transpired and under what circumstances in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights.
And this is where this thing of the sources of Abramji and Deputy Jones come in, that there's actually talks between the IDAC and Matlala to start afresh and talk about the plea deal. I don't know what would be unique this time, because the judge has said what he said. Unless maybe they are thinking about appealing it to the High Court, and instead of approaching a magistrate court, going up here and approach a higher court. I don't know if maybe that would be the new approach that they will take, but I just don't understand what is the plan, because it doesn't look like there's anything new here. It looks like the things are still going to remain the same. Or maybe they're going to take the 12 years, but they're going to decide how they're going to do the 12 years. Because we know in South Africa, if you're going to take 12 years in incarceration, there's certain things that you might get, for example, parole or whatever the case may be, after a certain number of years. So I don't know what this new plea deal that they're actually negotiating. Hence, I see why Advocate Van Heeven is actually interested in this plea deal and understanding it properly. Not because I don't think it's about the 1st of September. The 1st of September will come, and I still think the 360 million tender, it will be one of the things that they're going to argue to not actually discuss before the Madlanga Commission. Because I think that the basis of her argument using the plea deal is because the plea deal, in as much as we are thinking it's null and void, it's over, but for them, as well as the IDAC, it's still pending. There's just a lot that is contained in that plea deal. That is why I'm saying that I think there's a lot that is happening in the background that Advocate Van Heeven is actually not exposing us to, no one is exposing us to, but I wouldn't be shocked if indeed the sources of Pule and Abramji are actually telling the truth, of which they've never lied. If you guys we become honest, ever since I've listened to these guys and their sources, I've never seen them lying. They actually always tell the truth. It might not be something that happens tomorrow, but some other day they get to be proven right. So I do believe that definitely there's a plea deal that is currently being concluded by Matlala and the IDAC, and it's another one that now incorporates this Advocate Van Heeven, and she's now, assisting with putting in the terms of that particular plea deal as to what should be contained there and what should not. On the argument of the Constitution, I'm not going to lie, for me, she came across as someone that is constitutionally excited. That they call it constitutional overexcitement. She relied so much on the Constitution, talking about how it overrides the Commissions Act, of which it is the truth, because the Commissions Act is created to give spirit, purport, and object of the Constitution. It cannot be that the legislation can be above the Constitution. The Constitution is the supreme law of our country, and it's the one that is giving effect to the legislation. And the legislation, whatever that is created, it has to give spirit, purport, and object of the Constitution, meaning that it has to promote the rights that are contained in the Constitution. It can't suppress the Constitution. That is why I'm saying that she used the strategy called constitutional overexcitement, which is a people that love the Constitution. Everything, it goes back to the Constitution, the Bill of Rights, and everything that is contained in the Constitution for them to advance certain arguments.
I am saying I'm not interested in the nitty-gritty of what falls under the Section 35 packet. I'm not interested in that nitty-gritty. I'm looking at the broader question of on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket. Even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to the next point.
No, I do understand you quite...
And the moment, at most cases, guys, if you're going to use the Constitution, in as much as our rights are limited, there's a limitation clause, which is Section 36, if I'm not mistaken. Even though there is a limitation clause that limits your right, but still, no legislation can override the Constitution. And in this case, it's like she put the commissioners in the corner. And I understand why it came across as if she was an excellent legal representative or she was just excellent. People were like, oh my God, but she's good. I think it's because of that argument that she raised. I think the one of the plea deal was very, very weak in my view and in my opinion. Hence, Advocate Stillo was able to come with a very strong counter-argument regarding the issue of the plea deal, of which we'll talk about her arguments regarding that. But it looks like she was more leaning towards that constitutional overexcitement. And she did not listen, guys. The question that the Madlanga Commission was asking is that why don't we continue with the matters that we can talk about that are not contained in the plea deal, that are not contained in the case that you're about to go to in terms of the trial. And it doesn't look like she wanted to listen to that. She wanted to just put a lot of power on the Section 35, constitutional overexcitement. She put a lot of power over Section 35.
Is that this is raised, or this is being raised in a blanket fashion, is the suggestion that any and everything that Mr. Matlala could ever say before this commission would be something that would be subject to the exercise of his Section 35 right? Is that what's being suggested? And that there is nothing whatsoever that he could ever say which would be unaffected by his Section 35 right? Is that what's being suggested?
That is not what I'm saying, and I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time, and that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client, and I was not party to that particular agreement, I only came in later, through a different legal representative with IDAC, the gentleman that's been named here was part of that, entered into to a 105A plea agreement.
Because she's more of now the Section 35 matters. My client not be incriminating himself. My client has a right to a fair trial. My client has a right to be presumed innocent until proven guilty. Of which we love those arguments, Miss Overexcitement, Miss Over-Constitutional Excitement. We love them. But I think Madlanga was specifically asking, can't we continue with what we can continue with? And she was failing to answer. Hence, that kind of looked like altercation that happened, and people with that type of I think it was because she does not want to understand. That is why Madlanga even said, you will never understand me. Did not ask you that question. You don't want to understand me. And I think that emphasis was to prove to her that she does not want to understand and talk about the other things that they can talk about outside of this, the ones that she feels like as falling under Section 35, which is the ones that are part of the plea deal and the ones that are going to be discussed during the trial that is going to commence on Monday.
And you're right, I advise my client. That is my duty. But I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client. because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
So basically he's saying that she was saying, citing even people like Lieutenant General Mkhwanazi, and the fact that there's people that came here and gave unlawful evidence, and gave evidence which they obtained unlawfully. That her client went through a lot of trauma under police custody, and these people were obtaining unlawful information unlawfully from the client. And she specifically spoke about Lieutenant General Mkhwanazi, which was fixed by Madlanga, that there's many people that have implicated Matlala. It's not just Lieutenant General Mkhwanazi that actually implicated him. And it looks like already there is that certain behavior from her, because she was even suggesting that she wishes, the way she was putting it is as if it was for her, she would cross-examine Lieutenant Mkhwanazi right now about what he said about Vusumuzi Matlala. And I think all of that, it's like she's deviating focus. It's like she wants to do a lot at once. She's using everything that she felt at that time was going to be useful for her to push that argument and that thing of, let us not testify today, let us postpone to another day, because I'm still negotiating with IDAC, because that's what's going on right now. I'm still negotiating with IDAC, and also I want to first conclude, see how that goes before I can come here at the Madlanga Commission, decide what we can talk about and what we can't talk about.
Can I ask you this question just to make sure that I understand your position? Is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDAC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala and he will never testify. Is that what you're saying?
That's not what I said.
Then what is the relevance of the IDAC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so.
So here, the counter-arguments that were raised by Advocate Silo were specifically focused on the fact that this is like a waste of the Commissioner's time, and that we are not saying that Matlala's rights should be reserved. They should be put in the corner for some time. But they need to put an end to all of this. She even said that there's a moving target, and that they need to put an end in all of this, and that the Commission has limited time, and that they cannot now and again play on the palm of these plea deals and say, going to wait for the plea deals, because what if 5 more other plea deals come forward? What are they going to do? Are they going to have another postponement because there's many other plea deals that are coming forward?
Whether I understood her correctly, it gets worse, because now it sounds like the Commission shall be hamstrung by any plea deal that Mr. Matlala may choose in any criminal trial, whether ongoing or in the future, to conclude. So, effectively, if Mr. Matlala were to tomorrow face 5 charges in 5 different criminal trials, and he considers whether or not to conclude a plea deal in any one of them, then this commission is hamstrung, unless I completely misunderstood Ms. van der Heever. My understanding would be, I don't believe she would suggest that. But at the same time, then I struggle, what exactly is being suggested regarding these plea deals? And once again, I have no clarity. I submit, commissioners, that the only position to assume is we have nothing to do with any plea deals that Mr. Matlala chooses to conclude anywhere in any court.
So what do I think? I think I'm not going to take it away from her. She did a really good job, in my view, to raise that constitutionally overexcited argument of putting a lot of weight on Section 35, despite the fact that she knows that the rights in the Constitution are always limited. I liked that she did that meticulously and she was able to convince the commissioners. But I believe that the basis using the plea deal as well as the trial to give too much weight to the Section 35, to me was quite weak, especially the plea deal one. And I loved the counter-arguments of Advocate Sesi Baloyi more than her argument when it came to the particular issue of the plea deal. What's going to happen? What is going to happen is that in the next few weeks, what you're going to hear is that Matlala has concluded another plea deal with the IDAC, which then will also play a role in limiting some of the things that Matlala is going to say when he appears at the Madlanga Commission. So the intention is clear. Matlala does not want to testify about certain things at the Madlanga Commission. There's things that he doesn't want to touch at all, which is also the same behavior that we're seeing from Suliman Karim. Because we're hearing that Suliman Karim, they've been trying to get his bank statements. He does not want to submit his bank statements, but his businesses are operating. He's traveling. He's going to restaurants, he's going to shopping centers at Woolworths. He's seen in CCTV footages and car registrations. And what is worse is that he's going to social gatherings in the Northwest. So it looks like he's in the travel and tourism. One moment he's in the Western Cape. The next moment he's in the Northwest. That's how it looks like. But mind you, this is a man that was reported to be sick and could not appear at the Madlanga Commission. I don't know, for the last 3 or 2 postponements. He has not appeared.
My learned friend must choose his words very carefully, with all due respect, because my learned friend talks about hundreds of millions of rands, companies that are continuing to service the state, multi-million rand businesses and so on, and he uses the quantum of my client's otherwise legal business to evidence some or other gratuitous behavior in front of the commission. Until such time that a court orders otherwise, that there was unlawful business dealings with the state to the tune of those hundreds of millions of rands, the fact that there's business that may or may not be done to the tune of hundreds of millions of rands is neither here nor there.
And that's the thing, he's stalling the commission, and what makes it worse is that he's not compliant, not in terms of him appearing, but in terms of him submitting the relevant documentation that they have to use for them to actually start with the investigation, start with their probing. Because they can't just talk about Karim without putting it to you to see the discrepancies, the lies, the things that they have a problem with regarding the information that he has provided or his testimony. So, Suliman Karim, unfortunately for him, there were whistleblowers that have seen him living the life at its largest. This man is a man that we're told that he's very sick, and there's a medical report that has been provided. So what Advocate Carrim is saying, that let us subpoena the doctor to come and testify. And the doctor is currently faced now with the charge of obstructing the Commission's Act as well as defeating the ends of justice. Because that is the doctor that said Karim is very sick. But Karim is seen in the streets with his entourage, living the life at his fullest, going to restaurants, going to malls and all of that.
And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Karim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Karim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Karim's appearance, or non-appearance, to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring about 10 o'clock tomorrow.
Even though the argument that is raised by his legal representatives is quite, I can say it does make sense. Because they're saying that it does not mean just because a person now is going to these malls and buying stuff, that means that they're fine medically and that they have to now appear before the Madlanga Commission. If you guys remember my video the one that I posted yesterday, that the Madlanga has to do an inquiry to see that indeed these people are incapacitated. That's one of the things that I think are very important, but there's no need now because there's whistleblowers that have came forward to blow the whistle regarding the whereabouts of Suliman Karim and what is actually going on with him.
When you read paragraph 1 of that report, that will deal with my learned friend's contention that there's an inability to explain attendance. And when you read paragraph 2 of that same report, particularly lines 2, 3, and 4 of the second unnumbered paragraph, that is a direct response by a medical practitioner as to why, potentially, there's an inability to give answers. So insofar as my learned friend says there's just no explanation at all, that's contradicted by the medical evidence of an expert in a particular field of medicine, which my learned friend is not.
So there's a couple of things that looks like are questions that the legal representatives of Mr. Karim has to answer. And one of those is that he needs to provide admission dates, how he got admitted in hospital in the last 4 months, the consultation dates in the last 4 months, the travel movements in the last 4 months, social gatherings in the last 4 months, how he traveled from Northwest to the Western Cape in the last week, and how he got hospitalized there. And also she's going to be asked about the management of his businesses in the last 4 months. So these are the questions that he has to answer when they come again at the Madlanga Commission to start talking about what is going to happen going forward with this case of Suliman Karim. But it looks like the overarching issue, it's his appearance, because he's been lying about his appearance, but also the documentation that he has to submit, his bank statement regarding his businesses. Because apparently his businesses are just, literally operating. Everything is going well. But the legal representatives, I didn't like their reply. They came across very rude, calling the behavior of Advocate Skosen a smear campaign against their client, and even said it's gratuitous. I'm not happy about that approach. They're also putting the argument that they are undermining the medical reports, and they just want to do what we call reverse honors. I just think that they're just trying ways. I feel like the legal representatives of Suliman Karim, guys, are very manipulative, are legal manipulators. I know that advocate is really good, but I just think that sometimes it's the use of this language and English that these legal representatives or legal minds use to intimidate people in courts. And I just think that's what this legal representative is doing, is to try intimidate Skosen and try make you as an audience think he's smart. Because that's what happens in courts, guys. A lot of people use such words, and you, as the person sitting down, you'll think, hey, this one is smart, ne? Can't you know? It's not that deep, Shem. He knows he's in the corner, and he has to find a way for him to get out of the corner because he knows, and it's clear that the client just got busted. So it looks like what Karim was doing here is to get himself sick and also his business sick, but for the Madlanga Commission, not for everybody else and his businesses. Everything else in his life still continues, and he's just postponing, just going to the Madlanga Commission without even providing the proper and adequate documents for him to actually postpone. He just wants to postpone and, just get on with his life and just keep on postponing, get on with his life and keep on postponing. So here are some of the theories that people have thought of when it comes to the Suliman Karim situation. The first one is the fact that the reason why he's not submitting his bank statement is because he is currently in trouble with the SARS.
Actually requesting these financial statements to see if whether, firstly, he is not evading tax, secondly, that there is an auditor looking into his financial books as well, and compliance in terms of how they've been awarded the tenders and if the work was executed in some of these areas in the Northwest.
Pule, there's no doubt that Suliman Karim is well connected, especially in the Northwest. We know he's a treasurer for a local regional ANC branch in the Northwest, in the Mafeking area. We know that he's received a lot of tenders, especially road tenders, from the provincial government. we believe that the Commission wanted to get to that. But remember, the allegation at the time was, and he confirmed it, that he gave Vusiket Matlala a so-called loan. We also know that he had dealings with Morgan from the Tembisa Hospital scandal, and we know that a large sum of money, I think 50-some odd million, was transferred into Suliman Karim's or one of his business accounts, and 5 minutes later he transferred the money to Morgan's sister's account. That could be seen as money laundering, and that is what the Commission wanted to answer. We also know that there was an amount of about 1.5 million, if I can recall from his testimony, when he was confronted here at the Commission, to say that what was this money? He said, I wasn't even aware of the money, and he was supposed to submit the statements from the accountants or the managers, and that is what the Commission has been waiting for. So a lot of questions remain unanswered.
Meaning, there's high chances that Mr. Suliman Karim is not really compliant with the SARS. Hence, is dodging the Madlanga Commission and the submission of the documentation that much, because if indeed that is caught, we know Advocate Choskasen is not going to keep quiet. He's going to expose him. And not just Advocate Choskasen, is going to even be exposed to the public, which will then make it easy for SARS to actually indeed go for him. Because those are the rumors that are making rounds that he's probably not paying the SARS and is owing SARS a lot of money. And being exposed like that, we know that, guys, what happens when SARS sees that there's millions and millions of rands coming in and out of your accounts, they start looking to check if whether you are compliant or not. And the next thing, they're coming to repossess everything so that they can satisfy the debt that they believe you have with them. That is number one. Of which, yeah, guys, creators, YouTubers, guys, we must pay that SARS. Pay that SARS. Yeah, I know that 17,000, that 7K, that 5K is too small. You have a lot of responsibilities, but pay that SARS, Chomi. Pay it. You'll never regret. And then another one is the issue of subpoena. A lot of people were saying, why not subpoena the bank statements of Mr. Suliman Karim? I think they've already subpoenaed. But they want to hear from him. They want to see what he is willing to submit so that the cross-examination can be a little bit easier. Because imagine if they just relied on what they've subpoenaed. They don't even know which is which, how, where. They might assume. But if Suliman Karim submits the bank statements, it will be easy for them to actually find out the discrepancies, find out the mistakes, find out the problems, get to see what is actually going on, because he would have submitted Yena from his willingness. I don't think the Madlanga has not done that as yet. Just think that they want to hear from him what he has to say. Imagine if you found out about my personal circumstances, then you go and tell everybody without hearing from me. Don't you think it would be much more valuable if you heard it from me, telling you that I'm an admitted attorney, I'm what, I tell you everything about my life, and then you go, you research, you find something else, then you can cross-examine me on what I've said about me. But you can't cross-examine me when you don't even know the facts, when you don't even know what is my case. So I think that's what is going on right now with the Madlanga Commission. Now let us pierce the corporate veil. Let us pierce the corporate veil, right? Suliman Karim is a businessman, guys. Suliman Karim has businesses, and you don't know how many banks he has businesses with. You can go to Capitec, and he has a business with Absa Bank, FNB, Standard Bank, African Bank. You don't know how many banks he has businesses with. He can go and subpoena all these banks, but he's not sure if this is it and that's it. It ends there. So sometimes it's easier if Yenu Karim can go to these companies, to these banks and ask for bank statements and then submit to him, because of the fact that this man is a businessman that has a lot of businesses and probably has a lot of bank accounts. His bank account is not only with one bank.
The Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Karim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Karim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses.
So I think that is why it's not easy for them to just say we are subpoenaing or we are just going to do research and find out how many companies he has and all of that. Because remember, there's things that he might hide, that he's hiding, probably even the researchers or private investigators don't know about. But affording him the opportunity, he can even talk about what they don't know that, he has. But Suliman Karim is running away even from that very thing. Hence, there is that belief that, why not subpoena? But I think for me, the way I see it, they've subpoenaed what they can subpoena. And they just want to hear from Karim and see from Karim how many times. Because guys, remember, Advocate Juskasen was able to reveal that there was 300,000, there was 3 million that was paid by to Khontle specialist by Karim. There was another time where he proved that Karim paid 500,000 to Hangwan Mamel. That information I don't think Karim gave. Advocate Juskasen had to do his own research, had to go and do his own subpoena and gotten those documents and gotten that information. So that's what I mean when I say that these commissioners, they know what they're doing and they know that they have the information that they have. But that's the thing. The trick is that they want to hear what he has to provide. It's sort of like a trap. Sort of like a trap. Let us hear what he has to provide. And then that's when we can talk about what we have in conjunction or in questioning what you have and see who's lying and who's telling the truth. Other matters that I think are worth noting and are worth talking about very quickly is the fact that Andrea Johnson has apparently, from what we're hearing, was put on leave until the 15th. So this thing of her being sick, she was booked off until the 15th, which is today. So which means from tomorrow she's available. The evidence leaders said it looks like Padiachi is actually going to continue, but I don't think we should rule out the fact that even the IDAC leader might appear. So I don't know if indeed she will appear or another date will have to be scheduled, like a definite date, not this thing of having indefinite dates. It's going to be determined or confirmed for her appearance. But does not look good for her because even the spokesperson, Mangwenya, spoke about how the president is actually worried about the IDAC.
Second question, indeed, the developments that are transpiring at IDAC are a concern to the president, and the president is keeping an eye on those developments. At this stage, we've seen a lot of speculation around the head of IDAC potentially resigning and so on. Our view in that regard is that we're monitoring developments, and should the president reach a point where he activates some form of due process in response to the issues that are transpiring with IDAC, we will communicate that at an appropriate time.
And what is going on there? We don't know also if tomorrow indeed she's going to resign, because there's been a lot of rumors throughout social media that she might resign. So also that is another thing that can possibly happen tomorrow, so that she can just run away from everything. But if the president is worried, high chances Andrea Johnson might actually be fired. Either she's going to be fired or she'll have to make it easy, of which people like her in her caliber, most cases, they just make them to literally resign. So it does not look good for Andrea at all. But for me, I don't think the problem is Andrea. Andrea is just the piece of the problem. The problem is the IDAC. The IDAC has a serious problem, of which we're going to have an episode, as I've said, regarding this whole thing that is happening with the IDAC, and probably I'll try release it tomorrow. If not, I'll try tomorrow, definitely, to release the video regarding what is going on with the IDAC. But it looks like she's under a lot of stress, the way it looks. Either she's going to resign, the president's not satisfied. It's a lot happening with her. I know you guys got you. I know you get it. Nonetheless, guys, let me hear your thoughts. Let me hear what you think about these two individuals, these two cases. Very interesting, I must say. I really enjoyed what happened. And yeah, I know I still owe you guys the episode of Pariache. It's still going to come. I can't wait to do the comparative study with you with that particular case, because that's the intention for that particular video. And I know I owe you what is happening with the ad hoc committee. We're going to talk about the ad hoc committee. We're going to talk about the case of Ramaphosa as well as the TRC cases. Very important. I'm going to make one video that is going to incorporate all those three topics, and we're going to talk about them. But for now, let us consume what we just got today. What you guys think about everything? Let me hear your thoughts, your comments, everything. Don't forget to tell your families, to tell your cousins, to tell everybody, to tell your husband and your kids that I am on YouTube, and you have to subscribe and comment. Yes. Then, guys, I'll see you guys in my next upload. Bye.